woman who works nearby told us the house was absolutely trashed by the Siders. She knows the man who owns it. And we previously told you that the man who rehabbed the house told ABC6 in Columbus that the house was full of urine and pet and human feces. The man also said the attic was full of children's clothing, as if someone was living in it.
There is an audio recording of a county commission meeting in Vinton County, Ohio, made on the morning of Tuesday, July 14th. 3 elected officials in a small room. Budgets, line items, county business. You can hear chairs move. At one point, somebody laughs. It is the most ordinary sound in American government. And somewhere in the middle of a routine request for money, the county prosecutor says the sentence that ends a family. He tells the commissioners that Vinton County will be asking for permanent custody of all 16 Siders' children. Permanent. That word is not paperwork. It means the state of Ohio intends to make sure these 4 adults are never legally parents to those 16 children again. Not after a trial, not after treatment, not after 10 years of doing everything a court could ask of them, ever. It was said out loud in a public meeting with a recorder running, 3 weeks and 1 day after deputies opened that door on Omer Street. Elizabeth Sider's attorney has filed a motion stating that his client's one goal is to get out of jail and be reunited with her children. The paperwork moving in the opposite direction was filed by people who have already seen the medical reports. Before we go further, this case involves the abuse and neglect of children. I won't show them, name them, or describe their conditions for shock value, but if this subject is heavy for you, take care of yourself while watching. If you're new here, this is Quiet Record. Verified reporting, named experts, nothing invented. Subscribe if that's what you want. Tell me in the comments where you're watching from. And to everyone who's stayed with this case across 4 episodes, you're the reason it's still being asked about. Thank you. Because tonight isn't about what happened in that house. It's about what happens next. And this week, for the first time, the state of Ohio answered that question. Let's start with what permanent custody actually means, because most people have never had a reason to learn it. American child welfare law is built on one assumption, and it is almost impossible to overstate how strong it is. Children belong with their parents. Every part of the system bends toward reunification. When a child is removed, the default is temporary custody. The state holds the child while the parents work a case plan. Counseling, housing, treatment, supervised visits. The system is designed to give parents chances, and then more chances, because the law's position is that even a badly failing family is usually better than no family at all. Permanent custody is the exception to all of it. It is the state saying, this cannot be repaired, and we are not going to try. It terminates parental rights entirely, the legal relationship, not just the living arrangement, and courts are deliberately reluctant to grant it, because it is the most severe thing a child welfare system can do to a family, which is what makes the timing so extraordinary. Mark Pittman spent 44 years as a prosecutor in Ohio, retiring as an assistant chief prosecutor in Hamilton County. He has handled cases like this across the state. When Angenette Levy told him Vinton County was seeking permanent custody this early, his reaction was immediate. The main goal of Children's Services, he said, is to reunite kids with their parents. To move for permanent custody at all is unusual. To do it this fast tells him one thing. The situation had to be so bad that no one in that system believes these children can ever safely go back. His exact read, these kids must be permanently damaged. He compared it to a case he tried himself in Hamilton County, where the county took permanent custody because there was no conceivable future in which those children were returned. And he said the quiet part that every parent watching this has already thought. He doesn't care what these adults do from here. In his judgment, no one could in good conscience send those children back. Now, that is a former prosecutor's professional read, not a court ruling. No judge has granted anything yet. All 4 defendants are presumed innocent, and a dependency case is a separate proceeding from a criminal one, with its own hearings and its own standard of proof. But here is what makes his read hard to dismiss. The people asking for permanent custody are the people who have actually seen the medical reports, the placement records, and whatever came out of that house on June 30th. We haven't. They have. And after 3 weeks with that information, their conclusion was not, let's build a case plan. It was, these children are not going back. Sit with the arithmetic of that for a second. 16 children, ages 17 months to 18 years. 4 adults, 2 of them grandparents, and a county with fewer than 13,000 residents has decided, 3 weeks in, to try to end all of it permanently. And understand what permanent custody actually opens up, because this is the part nobody explains. Once parental rights are terminated, children become legally free, which means adoptable. For the youngest ones, the toddlers and the 4-year-olds, that is genuinely a door to a different life, a permanent family, a name on a school form, a childhood that gets to start over. For the older ones, it is far more complicated. Teenagers are the hardest children in America to place, and the oldest of these 16 is already 18, legally an adult, described by officials as developmentally still a minor, standing at the edge of a system that mostly stops catching people at exactly that age. So permanent custody is not a happy ending. It is the removal of the worst option, and the beginning of 16 separate, very different, very long roads. Then there are the mechanics, which are staggering for a county this size. 16 dependency cases, 16 sets of hearings, a guardian ad litem appointed to represent each child's own interests, separate from everyone else's, attorneys for 4 adults who will contest it, because parents almost always contest it, and they are entitled to. All of it running in parallel with a criminal prosecution, in a courthouse that convenes a grand jury 6 times a year. Which brings us to the room where he said it, because the setting is its own story, and almost nobody has heard it. If you have never listened to a county commission meeting, understand what this is. It's 3 elected officials in a small room, working through the unglamorous machinery of local government. Road funding, building maintenance, levy discussions. It is not where national news happens. And into that room, on July 14th, walked the man prosecuting the biggest case in the state. Archer's request was modest and specific, $20,000 for a separate line item for the Siders case. If it isn't spent, he told them, it goes right back. He explained why he needed it, the overtime, the sheer administrative weight. A case of this magnitude, he said, is not an easy thing to do. He has help from the Attorney General's office, but they carry their own caseloads. And the Siders case, he reminded them, is not the only case Vinton County has. The other cases don't stop. Then he laid out the actual scope, and this is the part that should get your attention. There is the criminal case, the 16 child endangering counts against each of 4 defendants. There is the Children's Services case, where the county will seek permanent custody of all 16 kids. There are what he called the related cases that started all of this. The original investigation, the one behind the sealed search warrant that nobody outside law enforcement has been allowed to see, which he says is going to be involved as well. And there is a 4th front. He told the commissioners they may do something about the house and about the people trespassing into it. 4 separate legal tracks running at once, out of an office in the least populous county in Ohio. His own summary of it, it's really got a life of its own. And then, almost apologetically, it's not anything that I created. What the commissioners said back is the most revealing part of the recording. One of them told him to strike while the iron's hot, pointing out the county had already gotten foster care money from the state, and that he shouldn't be afraid to ask for more. Another put it bluntly, every official in Ohio has made public comments about this case. Tell them to put their money where their mouth is and help us out. There's a half joke about whether this is the moment to finally pass a levy. Another about a colleague suggesting they might finally get their new jail out of this. Laughter. A commissioner mentions that someone came in on Sunday just to check that Archer was okay while he was working. It is, on the tape, an ordinary group of people in an ordinary room absorbing something enormous. And it is the sound of a county doing arithmetic that no county this size was ever built to do. If you've been following this case with us, this is where I ask the one thing that keeps this coverage possible. A county commission meeting is not a viral moment. Nobody clips it. But it's where the actual decisions in this case are being made. And this channel goes to the meetings, the filings, and the line items, because that's where the truth about these 16 children is going to live for the next several years. Subscribing is how you keep that in your feed. One tap, then stay with me, because the reporter on this case just spent a day driving to every house this family ever lived in. Angenette Levy went and stood in front of them. The Siders family moved constantly. That much we established weeks ago. What's new is that someone physically went to the addresses and asked the neighbors what they remembered. And the picture that comes back is not a family in hiding. It's a family that people saw, repeatedly, and never quite registered. Start on Honeysuckle Drive, in Cheshire, Gallia County, the last house before Vinton. This is the address we told you about last episode, the one the rehabber described finding in ruin, the one with children's clothing in the attic. A neighbor there spoke to Levy but wouldn't go on camera. He remembered the family. He thought there were about 9 children. He said they kept to themselves, and while he did see kids outside sometimes, mostly they just stayed in the house. 9. In roughly 2020 or 2021, a neighbor's impression was 9 children. By June of 2026, there were 16 in a room. Whatever else those two numbers tell you, they tell you that the concealment got tighter over time. That at one point, some of these kids were visible enough to be counted, and then they weren't. A woman who works nearby told Levy the same house was, in her words, absolutely trashed by the family. She knows the man who owns it. And then she offered a detail that I have not been able to stop thinking about. Gary Siders Jr. used to come into the store where she works. He didn't buy groceries, he didn't buy diapers or milk or bread. He bought scratch-off lottery tickets. That's it. That's what she remembers him buying. And once, he tipped her $10. I want to be careful about how much weight one store clerk's memory can carry. But set it beside what officials have said about that household's finances. No SNAP, no cash assistance. The only known income 2 Social Security checks supporting 20 people. And a man buying scratch-offs and handing out $10 tips is a hard image to file away. Somebody in that house had discretionary money. Where it went, and where it didn't, is now a question with 16 children attached to it. The rest of the map fills in from birth records. A property on Poplar Church Road in Bidwell, where the family lived for several years, at least 2009 to 2014, the longest they ever stayed anywhere. A house on Garfield Avenue in Gallipolis around 2019, where another family lives today. And the earliest one, a Gallipolis address in 2008, surrounded by other mobile homes, where Elizabeth gave birth to the first of her children at 15 years old. 5 addresses since 2015 alone, according to those records. Then Hamden, first one house, then the house on Omer Street. Stand back from that map and you see something the phrase, hidden children, doesn't capture. These children were not sealed in a vault. They were moved. Repeatedly, across counties, past neighbors who counted them, past store clerks who served their father, past landlords who later found what was left behind. The hiding wasn't invisibility, it was motion. Now to the courtroom, where the defense made a small move this week that tells you a great deal about what they're bracing for. Gary Siders Jr. faces 4 misdemeanor counts of public indecency from 4 separate alleged incidents at the Omer Street house between May 23rd and May 31st, accusations involving someone in his own family. He was scheduled in court this week on that case. His attorney asked for a continuance instead, and got it. On its face, that's nothing. Continuances are the most ordinary event in criminal law. But Mark Pittman, the retired prosecutor, laid out why an experienced defense attorney would want this particular case frozen. Public indecency is a sex offense. If his client resolved it now, pleaded to it, was convicted of it, that conviction becomes a permanent fact about him. And if more serious charges were ever to arrive out of this investigation, a prior sex offense conviction is exactly the kind of thing a prosecutor could put in front of a jury. There's a second reason, and it's about the size of Vinton County. Every hearing puts his client back in front of a community of 13,000 people, from which a jury will eventually be drawn. Pittman's read, the defense doesn't want to do anything on any case until they know the full scope of what their client is facing. That is the posture of a legal team that does not believe this is over. Nobody has said additional charges are coming, but the defense is behaving as though they might be. And this same week, the prosecutor told 3 county commissioners that the case has taken on a life of its own. Pittman also raised a legal ceiling on this case that nobody else has named out loud, and it is worth understanding precisely. Ohio has a felony murder provision, If a person commits a serious felony and someone dies as a result, even without any intent to kill, that can be prosecuted as murder. Pittman cited the Marcus Feasel case from Claremont County, a child left in a closet who died, as the kind of situation the law was written for. Then he applied it here, carefully and conditionally. 2 of these 16 children were airlifted to trauma centers. 1 was intubated in critical condition. We know all 16 were treated and released, and we do not know their current conditions. That information is protected, and none of us are entitled to it. But if one of these children were not to recover, and were to die as a result of what happened in that house, then the charges in this case would not stay at child endangering. They could rise to murder. I want to be exact about what that is. A hypothetical, raised by an experienced prosecutor, describing a legal mechanism that exists in Ohio. It is not a prediction. It is not a report about any child's condition. As far as anyone has said publicly, all 16 children are alive and in care. But it defines the ceiling of this case, and it explains, better than anything else, why the state is moving as carefully as it is, and why a small county is trying to build a case that can carry that much weight if it ever has to. Which raises a practical problem almost nobody outside rural prosecution has thought about. How do you even convene a grand jury for a case this size in a county this small? Pittman has done it. He worked the Lucasville prison riot cases in Scioto County, a bigger county than Vinton, but still small, with a grand jury that met only periodically. What they had to do there is what he expects here: summon a special grand jury, seated specifically for these cases, and nothing else. Because if you present part of a case now and the rest 2 months later to a different panel, you have to bring the new jurors up to speed on everything already presented. An enormous, error-prone waste of time in a case with this much evidence. He also described the improvisation that small county work requires, and it is oddly humanizing. He once had a woman arrive for grand jury duty with a nursing infant, and when it came time for the panel to vote, he had to stand in a hallway holding a crying baby, because he was not going to risk someone arguing later that an unsworn person was present during deliberations. That is what a case of this magnitude looks like from inside a rural courthouse. Not drama, logistics. Enough jurors summoned that some can rotate out of votes and the panel still holds. One body of citizens hearing one case for as long as it takes. And the more evidence the state gathers, the longer that process runs, which is exactly why the prosecutor's public timeline keeps stretching. Pittman offered one more observation, and it is the sharpest answer anyone has given to the question that has driven this entire series: why keep 16 children out of school at all? His answer was blunt. If a child is being physically, emotionally, or mentally harmed, school is where people notice, teachers notice, and classmates go home and tell their parents. So-and-so said this today, so-and-so had this on her arm, and word gets out fast. In his experience, when parents keep children out of school entirely and never register as homeschoolers, the reason is almost never educational philosophy. It is that they do not want anyone else looking at their children. Set that against what this series has documented. A truancy file opened in Gallia County in 2021 and closed when the family could not be found. Children's Services contact in that same county, Levy has now confirmed it through at least 2 sources, followed, she was told, by the family leaving. 5 addresses in 10 years. A neighbor in Cheshire who counted 9 children. 16 in one room by June. Pittman's framing turns all of that from a mystery into a method. Every move away from a school district, every county line crossed, every year without an enrollment record. Under his reading, that is not a family failing to participate in the system. It is a family avoiding the only institution in American life that looks closely at children every single day. There is one more thread from this week, and I'm going to handle it exactly the way the reporter who raised it did. Mark Pittman spent 44 years prosecuting cases in Ohio. Asked what he thought investigators were doing with the electronic devices seized from that house, he answered from his own professional experience and said that in the cases he had worked, that kind of forensic search was usually looking for evidence of sexual abuse. He was not describing this family. He has no involvement in this investigation, no access to its evidence, and he said so. And Angenette Levy stopped the interview to make sure her audience understood that. On air, immediately, she told them, "We do not know the nature of the initial investigation." We do not know whether there is a sexual abuse component to this case. The authorities have not commented on it. She was right to say it, and I'm repeating her correction here, for the same reason she made it. So let me be as clear as she was. No official in Ohio has alleged sexual abuse in this case. No charge filed against any of these 4 people alleges it. Gary Siders Jr. faces 4 misdemeanor counts of public indecency, and he has not been convicted of them. What we actually know about the devices is what the Attorney General said. They exist, they were seized, and BCI's Cyber Crimes Unit is analyzing them. What that analysis finds or doesn't find is not something anyone outside that lab is in a position to tell you tonight. I'm including this because it was said on the record, on the largest legal news program covering this case, and you deserve to know what's circulating and where it came from. I'm framing it this way because the distance between an experienced prosecutor describing his general experience and investigators are looking for evidence of sexual abuse in that house is the entire distance between reporting and rumor. And that distance is about to matter more than ever, because this week the courts narrowed the flow of information again. Judge Rogers has now granted a second gag order in this case, this one at the request of Christina Siders' attorney. It's less restrictive than the order she signed in Gary Jr.'s case, the one the Columbus Dispatch is challenging at the Supreme Court of Ohio. But the direction of travel is unmistakable. 2 orders now sit over this case. The officials who know the most are constrained from saying it. And every week, the public's window narrows a little further, while the questions multiply. Which makes what happened next genuinely surprising, because in the same week the courts closed one door, an agency opened another, and it answered a question this channel has been asking since episode 3. For weeks, people watching this case have wanted to send something. Money, clothes, toys, anything. And for weeks, the honest answer was, don't. There was no legitimate channel. The state hadn't set one up. And anyone collecting donations in these children's names was almost certainly collecting them for themselves. That has changed. South Central Ohio Job and Family Services, the regional agency carrying these 16 placements, has published an actual list of what the children need, with a physical drop-off location on Western Avenue in Chillicothe, Ohio, open on weekdays. The address is in this video's description. And I want to read you part of that list, because it tells you more about the condition of these children than any press conference has. They are asking for toys, art supplies for coloring and drawing, journaling and scrapbook materials, fidget toys, magnetiles, puzzles with handles, baby dolls and plush toys, push-behind walking toys, learning and sensory toys for infants and toddlers, specifically for gross and fine motor skills, learning materials for preschool through 12th grade, flashcards, books, learning games, children's clothing in all sizes, diapers in all sizes, pull-ups in all sizes. Read that list slowly, and it stops being a wish list and starts being a diagnosis. Puzzles with handles are for children whose fine motor control isn't where it should be. Push-behind walking toys are for children still learning to walk. Sensory toys for gross and fine motor skills are what you request when development has been interrupted. And preschool through 12th grade learning materials in a single request means an agency is preparing to teach a household of children whose ages span 16 years and whose education, in some cases, appears to have started at 0. Diapers in all sizes. Pull-ups in all sizes. The agency added one line that deserves respect. They will not be releasing the children's clothing or shoe sizes to the public. Even now, even while asking strangers for help, they are protecting the only thing these 16 kids have left, which is their privacy. And they noted that anything not needed will go to other children in their care. So if you have been waiting for a way to help that isn't a comment section, that's it. Western Avenue, Chillicothe, weekdays, details in the description. So here, as of this recording, is the honest ledger. What is true? Vinton County Prosecutor William Archer told county commissioners on July 14th that the county will seek permanent custody of all 16 children and requested $20,000 in additional county funding for the case. He described 4 active tracks: the criminal case, the children's services case, the related original investigation, and potential action over trespassing at the house. Gary Siders Jr.'s attorney obtained a continuance in his public indecency case. Judge Rogers has granted a second gag order at Christina Siders' request. South Central Ohio Job and Family Services has published a donation list and drop-off location. Levy visited 5 former family addresses in Gallia County and spoke with neighbors, one of whom recalled roughly 9 children. All 4 defendants have pleaded not guilty and are presumed innocent. What is theory? Mark Pittman's read that permanent custody this early signals permanent damage to these children. The professional judgment of a former prosecutor, not a court finding. His analysis of the defense's continuance strategy, his observation about what device searches usually indicate, which he explicitly did not apply to this family, and which the authorities have never commented on, and whether any additional charges are coming at all. What is invention? Any claim to know these children's current medical or psychological conditions, which is protected information. Any account collecting donations outside the official channel, and every interior image of that house still circulating online, which the prosecutor has now confirmed he is investigating as possible trespassing. If you suspect a child in your community is being neglected or abused, Ohio's hotline is 1-855-OH-CHILD, 1-855-642-4453. You don't need proof. You don't need certainty. Reasonable suspicion is the whole threshold, and trained people take it from there. One last thing before you go. 3 weeks ago, these 16 children lived in a house their parents had moved them into, after moving them out of 4 others. This week, a prosecutor in a room with 3 commissioners and a recorder said the state intends to make sure they never live with those parents again. That sentence will be argued in a courtroom for months, maybe years. But it was said, and it was said early, and in child welfare law, early means somebody looked at what came out of that house and concluded there was nothing left to repair. 16 children are going to grow up as somebody's permanent responsibility now. Some of them are toddlers who will barely remember Omer Street. Some are old enough that it will be the largest fact of their lives forever. The court fight over what happens to them will outlast the criminal case, outlast the gag orders, and outlast the news cycle by years. This channel is going to be there for it. Not for the outrage. The outrage takes care of itself. For the follow-through. For the custody hearings nobody clips. The commission meetings nobody watches. The moment somebody finally unseals the warrant that started all of this. If you want that in your feed, subscribe and be here when it happens. 16 children were found in one room. This week, the state of Ohio started making sure they never go back to it. I'll see you on the next one.